Attorneys and deputies are expected to act in the best interests of the person over whom they've accepted responsibility and to follow the Mental Capacity Act Code of Practice. In the case of an attorney, this is the person who's been appointed under a power of attorney. The person who appoints them is known as the donor. In the case of a deputy, this is the person who's been appointed by reason of an order of the Court of Protection. Under the Mental Capacity Act 2005, it's possible to apply to the Court of Protection to remove an attorney or a deputy. In the case of an attorney, the removal is in fact achieved by revoking the power of attorney which appointed them in the first place. Section 22, subsection 3 of the Mental Capacity Act 2005 confirms that the Court of Protection may revoke a power of attorney where the donor no longer has the mental capacity to revoke the power of attorney. If they retain the mental capacity, the court has no power to intervene. And either fraud or undue pressure was used to induce the donor to create the power of attorney, or the attorneys behaved or proposes to behave in a way that contravenes their authority or isn't in the donor's best interest. If the power of attorney is revoked, then it will almost inevitably be necessary to appoint a deputy to act for the donor. In the case of a deputy, where a person objects to their conduct, an application can again be made to the Court of Protection, this time to revoke their appointment. Under Section 16, subsection 8 of the Mental Capacity Act 2005, the court must be satisfied that the deputy has behaved, is behaving, or proposes to behave in a way that contravenes their authority and isn't in the person's best interests. Applications to the court to remove a deputy or to revoke a power of attorney are governed by the Court of Protection Rules 2007. Examples of behaviour which often warrant an application to revoke a power of attorney or remove a deputy are where the attorney or donor fails to keep proper accounts or financial records, where joint attorneys under a power of attorney are unable to work together, where the attorney or deputy has authorised large gifts to be made out of the person's funds, or in any other way in which they're clearly not acting in the person's best interests. Given the seriousness of the power, the court will look at all the circumstances, including the seriousness of the behaviour or potential behaviour, and consider whether it's necessary and proportionate to revoke the power of attorney or remove the deputy, and if it be in their best interests.